This call is now being recorded.
All right.
All right. I'll go ahead and do the roll. Start with Nicole Bailey. I do not see her present. Andrea Chiribogaflor.
Here.
Thank you. John Conley.
Here.
Thank you. Mr. Forbes.
Here.
Thank you. Captain Hahn.
Here.
Thank you. Troy Hill. Do not see him. Jim Howes.
Here.
Thank you. Nicole Lawless. Do not see her. Michael Pierce.
Here.
Thank you. Gregory Prensky. Don't see him. Brandon Rich.
Present.
Thank you. Mr. Reister.
Present.
Thank you. Riley Nathan, that is myself. I am here. And finally, Joyanne Rusha. Do not see her. Okay, that's everybody. Thank you.
All right, great. Thanks, Nate. So I sent out the agenda. It's pretty bland. Basically, just talk about our objectives for this year and stuff like that. Although I do recall now, I think we discussed doing our kind of annual training during this meeting. Mr. Roberts, are we planning on doing that today?
It's up to Nate. What do you think, Nate? You gonna do it today?
Yeah, we might as well. It's hopefully we'll have a few more people trickle in. We may just have to hold a second session, maybe sometime later this month or next month to cover everybody who wasn't here today. But
Nate,
Nate,
if I have to prep twice for this, I'm double billing you so hard.
fair enough.
Well, I'm not sure if I can take direction from somebody in a Seattle jersey, though.
And just on top of the training, just so everybody remembers, we did take this same exact training back when we convened for the first time back in January of last year, so a year ago. We took this same training. It was handled by somebody else in the AG's office, but now that we have Mr. Roberts assigned, he's going to be handling some of the legal parts of the first half of the latter half of the training. I'm going to go ahead and take the first part where we just talk a little bit about the department, the PUC, and this body as a whole, kind of why we're here, what we're doing. It is by law an annual training requirement, so we're going to have to do it every year. I'm going to check with the department and see if we have to do those compliance affidavits every year as well. We can get away with just doing it that one time when I had you all sign them last year. Hopefully that's all we have to do, but there's a chance we may have to recirculate those, with the exception of Captain Hahn, who's a new member, so we'll have him fill out his for sure. And then I'll double check on the rest of you, and if that's something we need to do after we do the training today, or whatever additional sessions may be needed to do it, then I'll be sending everybody a copy of that affidavit if it's necessary for you to sign and return.
And also, Nate, a real quick note, we just got an email from Miss Lawless saying that she is going to get the minutes to us from, I guess, October and December. So I think we're going to have to push the minute approval to next month, but not a lot there, so not a big deal. But we will have to end up coming back and approving all those minutes.
Okay.
Cool.
Just real quick before we jump into that is that all right with you, Trevor, to jump into the training next?
Yeah, let's knock it
out. Before we get there, give me just 1 second. I had a couple notes here for a couple administrative type items. So I wanted to oh yes, Dr. Pierce.
Just was curious. We have an extra participant.
We do.
I was curious if we could be introduced.
That is exactly what I was just about to do. Thank you. Thank you for calling it out, Dr. Pierce. So yes, we do have a member with us today. It is actually the newest hire of my staff at the PUC. Her name is Khadija Abdirahman, and she is going to be helping us out a little bit with some of the administrative items related to the task force. Kind of a lot of the stuff that I've been doing kind of in the background, I'll be passing off to her at some point. Maybe not right away, but it is something that eventually she will be handling. So things like, sending out the meeting invites and, different things of that nature, the compliance affidavits, putting together the meeting notices that we do before each meeting, making sure those get put up on the website. Just a lot of the little things that kind of happen behind the scenes that I've just kind of been doing myself. I'm planning to eventually pass off to her. So, Khadija, do you want to introduce yourself real quick?
Yes. Sorry. Hello, I'm Khadija. I just started at with Dora just last month on the 27th, and I'm currently going to be working with Nate with the PUC. And my position did get created based on that towing bill that just passed in August. So I will be working closely with you guys, and I'm excited.
Welcome, Hadija. Glad to have you. I know Nate's team is quite in need of some help, so I'm sure you're a welcome addition to the team.
Yeah, we can always use some more help. But no, she'll be helping us with a lot of our different reporting requirements. As I'm sure you all know, they made some changes to our overseeing statute for this particular body, 4010.1403. They made some significant changes to the reporting requirements that the PUC is required to do on an annual basis to the legislature. Unfortunately, we couldn't get Khadija in on time to help with that report, so I did it all myself. But there's some good information in there, and anyway, it's just some figures and stuff regarding our regulation of the towing industry to the legislature. So we'll see if and how they use that. But okay, so I think we're ready to jump into the training, Mr. Roberts, if you're ready. I was going to take, I think, the first 8 slides, and then I think you could do the rest.
Let's rock and roll.
All right, thank you. All right, give me 1 second, and I'll share my screen here, and we'll get started. And if you want, Mr. Roberts, I can just share the whole time, and then you can just tell me when to switch slides when we switch to you.
Perfect.
Okay. So some of you will probably remember this from last year. Again, this is for the Towing Task Force members. It's just an overview of the different processes and procedures as it pertains to this body and the department. Again, this doesn't it's for training purposes only. It doesn't constitute legal advice. If you want to consult your own private attorney on some of these topics in more depth, that's fine. But at the same time, as we're going through these different items, if you have any questions, just raise your hand and we'll be happy to address them, I think, in stride. I don't think we have to wait till the end. So we'll just kind of go through this again. For some of you, it'll just be a reminder. But for some of our newer members like Captain Han, this may be new. Well, some of this will probably be pretty familiar to you, but we'll just get through it. Okay, so this is kind of the overlay of the training we're going to talk about today. So we'll start with an overview of the PUC, which is my agency, the agency I work for. We'll do an overview of the Towing Task Force. So this body, the statute that governs us, what we're here to do, why we're doing it, all of that stuff. Then we'll move on to what our duties and powers are, which is kind of linked to the overview of the task force. And then we'll move on to Mr. Roberts' portion where we'll be discussing the Colorado Open Meetings Law, best practices for running our meetings, ex parte communications, conflicts of interest, and of course, CORA, the Colorado Open Records Act, in which people can request information that we're working on and that information we're engaging in. All right, so let's go ahead and start with the overviews. So the overview with the PUC is an independent administrative agency within the Colorado Department of Regulatory Agencies. So that's DORA, which houses, I think it's about a dozen different divisions. So things like the Division of Banking, Division of Real Estate, Division of Securities, DPO, which is the Department of Professions and Occupations, Division of Insurance, and of course the PUC is included in that group as well. These are all under the executive branch of state government, just so everybody knows how we're allocated. The PUC does regulate a pretty wide range of industries in Colorado. Transportation, obviously, which is the most pertinent to what we're doing here. So it's not just limited to towing, of course. We also do moving companies, which we refer to as HHG or household goods. We do taxi companies, limo companies, shuttle companies, tour companies, TNCs, so like Uber and Lyft, and also they actually just recently added in the last few years vehicle booting companies as well, which kind of work in a somewhat adjacent way to towing companies. So anyway, a lot of different areas of transportation that the PUC regulates. We also regulate other industries such as the rail and transit safety industry, also gas pipeline safety. We also do some fixed utilities such as electric and gas utilities, as well as telecommunication and water utilities. So it's a pretty wide range of a spectrum that the PUC regulates. So we're definitely involved in a lot of different areas, and we have a lot of people on staff who have expertise in various fields. Moving on to the PUC commissioners and its staff. So we have 3 appointed commissioners. They are essentially the decision makers for pretty much all matters pertaining to the various industries that I just mentioned. Each position is appointed by the governor to a 4-year term. They are appointed by the governor and then subsequently confirmed by the Senate in order to officially take that role. We do have some other state roles regarding the body as well, such as that no more than 2 commissioners can be from one particular political party. So they stick pretty hard to that. The PUC, like I mentioned before, does have we call ourselves SMEs, subject matter experts, and basically that means that we are an expert in the different industries that we are essentially working. So speaking for myself, being part of the transportation staff, I've worked in transportation for just a shade under a decade, and have been involved in investigations, have a lot of knowledge in regards to our permits and applications, just our overall processes, waiver submissions, formal complaints, petition for declaratory order, rulemakings, legislative agenda type items. There's a lot of things that go into each of our, knowledge portfolios, so to speak. So there's a lot of people in these different industries under the staff category here. So like energy, telecom, transportation, rail safety, gas pipeline. The commission even has a policy advisory team that kind of gives them guidance on particular issues. So we have engineers and other professionals on staff as well. We have research and emerging issues. So we have essentially research teams that will kind of maybe study different areas of a particular industry and kind of see where things are trending in regards to policy, both at the federal, state, and local level. And then we also have strategic communications, and our consumer affairs team is basically our funnel for all the different complaints and people wanting to participate in our various matters. They all tend to go through our consumer affairs as kind of the entry point into the commission and the work that we do. As to the commissioners themselves, this is our current bench. So we have Commissioner John Gavin, Commissioner Megan Gilman, and then the chair, Eric Blank. They're all working their way. In fact, I think one of them's terms is about to expire. I'm not sure if potentially they're going to be reappointed or we're going to have a new appointee. So, but this is the current bench, and they've been working together for at least a couple years since I've been back as the chief. So very pleasant to work with. As to the director, obviously we have to update this. Director Doug Dean, who had been the PUC director for, I heard it was 18 years. I didn't hear the exact number, but I think it was, if it wasn't 18 years, it was close to 18 years because I think he came in 2005, I want to say. But anyway, he actually just retired back at the end of November. So we currently have an interim director, which is our chief administrative law judge, Harris Adams, is our current interim director. So yeah, we'll update this training once we get a new permanent director. Okay, moving along to the PUC regulation of towing carriers. Again, for our immediate purposes for this body, we're going to be talking obviously a lot about the PUC's regulation of the towing industry. The PUC's authority to regulate towing carriers is set forth in, amongst other things, these particular Colorado statutes. So we have our 4010.1401 statute, which requires towing carriers to obtain a permit from our office, the PUC. And it also sets forth requirements and conditions for that permit. We also have 4010.11061B CRS, which authorizes and requires the PUC to prescribe rules for towing. So in this particular instance, that particular statute references circumstances under which a towing carrier may perform a non-consensual tow, the responsibilities for care of a towed vehicle, as well as the minimum and maximum rates and charges to be collected for non-consensual tow and storage of a towed vehicle. Obviously, the PUC has adopted rules and regulation and operational standards beyond just that basic framework in areas that they felt it appropriate. They have adopted these rules under our 6000 series of the commission rules. Those are the transportation rules. For towing specifically, it's under the 6500 series, which is rules 6500 through 6514. We're actually just about to go, I'm sure some of you have heard, we're about to go into a rulemaking, which we're hoping to have in front of the commission by the end of this month, in which we're going to be essentially updating our rules to allot for recent legislative and statutory changes. Moving on, we have the overview of the Towing Task Force. That's us. So Towing Task Force is referred to as an advisory committee. It's created within the Colorado Department of Regulatory Agencies, or DORA. So it is a board. They also refer to it as a board or commission. They kind of lump all those into a singular category under the department. And it is overseen by our department, the Department of Regulatory Agencies. They rely on people within each agency to kind of help out with some of the administrative items. So that's kind of what I've been doing this past year. And actually even prior to that, when we were doing the recruitment for this body, we've been involved in kind of putting it together, but ultimately the department is the one who oversees what we're doing. Excuse me. So as of November 21st, which was a period where there had been some recent changes to the legislation, specifically under 4010.1403, which is our governing statute. It was the result of a House bill that they passed back in 2021. It was House Bill 21-1283, and it essentially kind of restructured what the task force was. The task force was in existence prior to that, and in fact, some people in this room were on that previous body before this statutory shift. But it used to be 9 members that were part of the task force, but they went ahead and increased it to 14 members. All of which, well, not all of which, but the majority of which, 12 of the overall 14 are appointed by the governor to either 2 or 4 year terms. The only exceptions to that is Captain Hahn's position in regards to, which is not appointed by the governor, it's appointed by the chief of the state patrol, as well as Mr. Reister's position, which is also not appointed by the governor, but rather by the attorney general. So those are the only exceptions. The rest of us, all 12, including myself, are all appointed by the governor. So, and then one of our other statutory requirements is that we have to hold meetings at least twice per year. As most of you are, I'm sure, remember, we met a lot more frequently than that last year in anticipation of the report that we had to submit by November. We did get that report submitted on time for the statute, so good for us. So we'll go ahead and move on. Towing Task Force duties and powers. So the Towing Task Force has the duty and power to, the primary one is to make recommendations to the PUC about tow rates. That's kind of the primary one. Basically, we're tasked with making comprehensive recommendations to the PUC about the maximum rates for the recovery, towing, and storage of a vehicle that has been towed without the owner's consent. And there's a statutory reference there. It's the 4010.14035A. So that's essentially that same language that's listed here in the presentation. In addition, the Towing Task Force was required to make its first comprehensive recommendations to the PUC about the maximum rates after July 1st, but no later than September 1st. They did change that. That's what it was when we first did this training last year, but due to some changes to the 4010.1403 statute that they made as a result of the House bill from last year, House Bill 2213-14, they actually bumped that from September to November 1st, and that's when we submitted it, was by November 1st. That, just in case anybody's curious, I think I've mentioned this already, but the report that we submitted last year, it is currently sitting in a repository docket at the PUC, and I believe our intention is to go ahead and splice it into the rulemaking when it gets started later this month. We might be able to just do it automatically since it's already in the PUC's records, but there's a chance they may want us as the Towing Task Force to refile it into that docket once it's opened. But I'll let you all know how they prefer it, and we'll make sure it gets done. In regards to just some additional minor pieces of our governing statute, it also instructs the PUC to consult with the towing task force when issuing or amending rules concerning towing rates. Obviously, with the report we submitted last year, it's a foregone conclusion that we're going to be involved in some capacity in this upcoming rulemaking. So I think we may have already met that criteria based on the upcoming rulemaking and the report that's going to be included in it. Also, there's another piece of this the statute that for us to make recommendations about investigations of overcharges. So basically, when there's overcharges as part of one of our investigations or complaints, the towing task force is tasked with advising the PUC or the PUC staff concerning these specific types of investigations. And again, that's available in the 4010.14035B statute. The statute also directs at the discretion of the commission. So in this case, it's the commission's call. The PUC staff can consult with the towing task force concerning investigations of overcharges made by towing carriers in violation of the statutes in Title 40. And again, that's available in the 4010.14034B statute. So I don't think traditionally the commission has elected to do that, but that may change in the future. Okay, I think that wraps up the first part of our training. So, Mr. Roberts, you want to take it from here, and then just let me know when you want me to switch slides.
Will do. We're going to switch gears. Does anybody have any questions for Nate about the first bit that we went through?
I think we had a comment from Dr. Pierce. Can you send the information regarding the rulemaking hearing when it's scheduled? What's on the agenda? Yeah, yeah, I can loop everybody into that when it's filed. Like I said, we expect it'll happen later this month. But yeah, it's not something. It's a pretty drawn out process, as I'm sure some people in this room are aware of. So it's not like something gets filed and then there's a decision made like inside of a month. Like usually what will happen is the commission will adopt the notice for proposed rulemaking and issue that decision where it outlines the proposed changes to the rules and certain areas where the commission wants to solicit additional commentary. And then it gets opened up just for general comments, public comments leading up to that public comment hearing. So there'll be plenty of time for the task force to become involved in whatever way it feels like it would like to or needs to be. But yeah, no, I'll make sure everybody on this body is in the loop on when that's occurring.
Okay. One of the reasons why I ask is I've been involved in suggesting rule text and was hoping to have enough of a head start to be able to do that in a decent way.
Sure. Yeah, no problem. Like I said, I can. Yeah, we'll make sure that you're aware when that's getting issued, that's being pursued.
Okay. Thanks.
Thanks, Dr. Pierce. Any other questions for me? All right, Mr. Roberts.
All right, moving on. So the Colorado Open Meetings Law states that it's a policy of the state of Colorado that, quote, the formation of public policy is public business. So it's intended to afford the general public and as many people in the public as possible access to a broad range of meetings at which their public policy is considered. What the Colorado Open Meetings Law mostly requires is notice that a meeting is going to happen, and that notice needs to be 24 hours in advance of the meeting. The meetings have to be open to the public unless they fall into an executive session exception, which we will get to in a couple of slides. And they need to be documented, which means we create and publish minutes of all our meetings. As the General Assembly likes to, you can move on, Nate, please. Next slide. As the General Assembly is wont to do, it likes to define well understood terms like what is a meeting, and a meeting is any meeting of 2 or more members that is convened to discuss the public business of the board or the task force or the committee or the commission, whatever it is. And a meeting under the Open Meetings Law is any 2 or more meeting in person, by telephone, electronically, or any other means, which that would include Snapchat, Facebook, email, chats of any kind, any platforms. I mean, since the pandemic started, there's so many platforms. I can't keep up with FaceTime or Snapbook, whatever it is these days. So there's all these things. If you converse with another task force member on any of those platforms about public policy, about public business, the business of the task force, that constitutes a meeting. A meeting doesn't include the like chance meetings or communications about purely administrative matters about like scheduling or rules that are going to be in place for an event. Next slide. All right, so I jumped ahead a little bit, and I apologize. I am working from, I have my screen, my outline, which I do this training for a number of other DORA programs as well. So I might not track exactly with the slides, but you'll get the idea by the time we're done. Public policy. I'm on the second paragraph of the current slide. Public policy is essentially any business that is that of the commission. So in this case, it would be determining reasonable rates for towing. So if it has anything to do with that, it's quote the formal or the public policy of the task force, and it has to be conducted in a duly announced meeting. Next slide. Executive session. I mentioned executive session. The open meetings law allows the task force and other boards to discuss matters behind closed doors, or in this case, virtually closed doors, in what we call executive session. So the executive session is where, in prior days when boards would meet in person, we would kick everybody out except the board members, staff, and the attorney. So anybody watching, anybody listening would be kindly excused, or not so kindly if they didn't want to go, excused from the meeting because we're going to talk about a number of things that we're allowed to keep private. So one of those is conferring with your attorney. So as you probably know, if you've ever had to take some legal action or defend yourself in a legal action, you have with your attorney-client privilege. So that communication with your attorney is protected from disclosure unless there's some showing of bad faith or some statute that allows it to be made public. So that's called attorney-client privilege. So we enter executive session to talk about pending or imminent court actions, specific claims, grievances, legal advice. For this program, the task force, I would expect that we might enter into executive session at some point to discuss some legal advice. So if the task force has some legal question for me, and I generate a written legal opinion, which I do on occasion, or there's specific questions that you'd like me to answer of a legal nature, we would enter executive session, and that's to protect the confidentiality of our communication. And that privilege is not mine to protect; it is the task force to protect. So we will enter executive session to protect your attorney-client, your privilege, and things that you say to me and things I say to you. Matters required to be kept confidential. Those can be such things as medical records, which HIPAA and the state medical board has rules about protecting those things. Academic results, people take licensing exams, those kinds of things. Those are protected by federal or state laws from disclosure, and we'll talk about those in executive session as well. And specialized details of investigations, I'm not sure how often that will come up here, but if we are conducting some investigation, we'll protect the ins and outs and how we go about doing those. Entering executive session, this is not on the slide, but just to let you know about how we enter executive session, there is a specific step-by-step procedure that we follow. First of all, the open meetings law requires that we record executive sessions. So we would have a digital recorder. Back when I started representing DORA programs, it was a tape recorder. I know I dated myself just there, but we will record the whole executive session. Mr. Hahn's laughing. I appreciate that. You're you're close to my generation, so you probably remember. And I'm not talking about 8-tracks here, John. I'm talking about regular cassette. Anyway, we'll record the entire executive session, and we will start with turning on the recorder. One of the task force members will make a motion. If we ever get to having to do executive session, I will provide a template for all of this. So Nate, Trevor, you guys don't have to worry about that. You'll make a motion for us to enter executive session, stating the reason. That motion also has to be recorded. So everything from beginning to end is recorded. We will state in the motion why we are entering executive session, and we have to be specific enough to disclose to the public the grounds under the statute that we're entering. So we can't just say we're entering executive session to talk about this oil lease. We have to say to talk about legal issues concerning, we have to be specific about it. There was a case a number of years ago where the City Council of Steamboat Springs tried to do a shorthand motion to enter executive session, and they got challenged. And the court said, hey, you didn't give enough detail. So everything in their conversation that they expected to be confidential was open, and I don't know if it was on the front page of the Denver Post, but it was somewhere in some publication that they did not want. So part of my job is to make sure that you don't get caught up in that. We must approve the motion. We're still on the motion to enter executive session. We have to approve the motion by 2/3 of the total membership. Once it's approved, we'll excuse all the members of the public. For this platform, just how I've seen it done is we will close out of this platform, this web platform, and go to something different, just like a call-in number that only each of you has. So you will call in so we can make sure we know who's on the call. Otherwise, there's really no way for us to know who's listening in on with the virtual platform. When we're in executive session, we can only discuss the items that we said we were going to discuss in the motion. So we can't wander off and talk about something that's an adjacent issue. We will put a pin in that and talk about that once we adjourn from executive session, but we have to restrict our conversation. And the last thing about executive session is that we can't vote. There's no voting in executive session, no quote formal action, which we've interpreted at the Attorney General's office to be voting. So we'll just get a consensus, and then any votes on issues that we've talked about in the executive session will come after we adjourn back into open. I like to define, and I'm going to date myself here again. I like to think about executive session as the big dome. You guys remember Get Smart, the old show back in the 70s? Or a little dome would come down and protect the conversation between the two goofy spies. That's executive session. So once we raise that dome and we're back in open session, we're good to go, and we can make motions. Next slide, Nate, please. So best practices for running meetings. I think this is pretty self-explanatory, so I'm not going to waste a whole lot of our time with it. But I think Trevor's done a nice job of facilitating open conversation and an equal right to be heard among the members. Our meetings, which Nate and Trevor put together nicely, hit all of these bullets. So I don't think we need to go much into that. I can answer questions if anybody has anything specific. Next slide, please, Nate. All right, ex parte communications. Ex parte, not to mansplain to anybody, but ex parte means without somebody else. So separate from without the other party. And in ex parte is in this context where, let's say this body entertained complaints from members of the public. Say somebody complained about a towing company to this body. What ex parte communication would look like is if the task force were to hear from the complainant without notifying the towing company that there was a complaint, or allowing that towing company to be represented in that conversation. It's like if a prosecutor were to call up the judge in a case without the defense counsel being present. That is unconstitutional. The ex parte, the prohibition against ex parte communication goes back to the U.S. Constitution, where everyone is allowed a notice and a right to be heard. And in this case, in these cases, strike that. In the case of task force and boards, it is often involves members of the public who have something to say, and we don't allow the respondent or the opponent to be present. As I said, the one-sided communication can prejudice other parties. The upshot, the potential consequence, which isn't on the slide either, the potential consequence of ex parte communication is that a court could undo any action that the task force or the board takes, and there is a potential for Section 1983, which is a federal statute, claims against the state, the individual board members or task force members for violating their constitutional rights. That can get expensive. I haven't seen it, but I'm ethically obligated to tell you where the risks and pitfalls are. Next slide. So the ex parte communication extends to the Public Utilities Commission commissioners and staff. So they cannot receive, like I just talked about before, they cannot receive complaints and hear the merits of the complaint without the other parties being present. That is an appearance of impropriety, and as a public body, the Public Utilities Commission and this body has to be sensitive to that. Next slide, please. So best practice here, I like to tell boards and commissions and task forces that your names are on the websites. Your people can find you, and if people call you and reach out to you, what your best practice to avoid ex parte communication is to say something along the lines of, and you can write this down, something along the lines of, I can't talk to you. I can't speak for the whole task force. If you like the task force to consider your issue, you give them Nate's number or Khadijah's number or something like that. But you just need to say, I can't talk to you. I'm sorry. I can't speak for the whole board or for the whole task force, and hang up the phone. Give me a call after that. Say, hey, this is what happened. Anything wrong with that? What should I do at the next task force meeting? What I'll probably do at the next task force meeting is say, for example, Trevor got called by a member of the public. He said nothing of consequence. He's all right to stay. If Trevor said anything of consequence to that member of the public, my advice would be different. It would be along the lines of, Trevor, you need to recuse from the task force conversation about that because you've engaged in ex parte communication. Okay, next slide, please. Conflict of interest, one of my favorite things. So there are two types of conflicts of interest. And a conflict of interest, obviously, as the slide says, is a private interest. It's usually a financial interest. So if you have an interest in a towing company that's being considered for some issue before the task force, you can't participate in that. So that would be a real conflict of interest where there's actual dollars, actual pecuniary interest involved. There's also what we call an apparent conflict of interest. And what kind of the short thumbnail for that is, if it looks bad as a public agency, which is what we are, if it looks bad, it is bad. So if you have a conflict of interest, we didn't know about it. If you think you might have an apparent conflict of interest, that if you were just to imagine it to look on how it would look on the front page of the Denver Post, that is something that I should be made aware of, and that we can discuss how to do it, how to handle it. Typically, the way to handle a conflict of interest, real or apparent, is for that member to recuse. An apparent conflict of interest could look like something like, if we're considering somebody's a complaint about a towing company or something along along those lines. And you as a task force member know this person, or your kids played soccer together. You guys like to watch the Broncos together on, when the Broncos are doing better than they were this year. If it looks like you might have some bias for or against, even if you don't, if it looks like you might, that's an apparent conflict of interest, and we should talk about it. Next slide, please. All right, this slide isn't of much substance. I think I've already covered all the points here. Next slide, please. So how you handle a conflict of interest, I've already alluded to it. The first thing you need to do is disclose it. As soon as you know or think you might have a conflict of interest, just let me, or if I'm not around, your attorney know that you might have, or you do have a conflict of interest. We'll advise you about it. And if you have a conflict of interest, then what's appropriate is to refrain from participating, and particularly refrain from voting. Okay, next slide, please. So the Colorado Open Records Act. So the default policy under the Colorado Open Records Act is everything that is written either in hard copy or electronic that a public agency generates or comes into possession is a public record, and that anybody can get access to it. They can inspect it, they can ask for copies, they can come into the office and look at it. This is kind of parallel to the open meetings law that we talked about earlier. It's making sure that we are as transparent as possible. Next slide, please. So a public record is, let's say, anything in writing, and you see the list there in the second paragraph. Just about anything. It's what the case law on CORA has determined is, or has directed us as the Attorney General and statewide, is that we have to take a broad view of what a public record is. So if there's a question, hey, is this a public record? The first answer is yes. And then we have to say, if it's not, why not? And then that analysis is subject to some pretty strict scrutiny. And this is all in the spirit of being transparent and making sure that the people of the state of Colorado have full access to decisions that are made and documents that are kept on their behalf. Next slide, please. So anyone can make a request. Anonymous press makes a lot of requests. And they can make it of any agency, even my employer, the Office of the Attorney General, receives regular CORA requests about cases, or even things that we're doing, or what we're paying our people, or our organization, or anything. And it doesn't have to. It's not restricted. It's for any purpose. They don't even have to tell us what their purpose is. And there are very few exceptions, which are on the next slide, please, Nate. So there are two categories of documents that are not subject to the inspection or production. I call them the must or may. They're the must or may different categories. If there's something where an inspection would be against some other public law, like HIPAA or something, where something is required to be kept confidential, then the custodian of that document, usually an agency employee, has to deny that inspection request. And there's no conversation after that. The person can go to court, but if it falls squarely under the must deny category, that argument is not gonna prevail. The other category is may be denied, and that's subject to the discretion of the custodian of records, as you see, such as administrative investigations, law enforcement investigations. I've seen denials for proprietary information. I represented the Mineland Reclamation Board for a number of years, and they routinely would deny requests for documents about mining claims as proprietary and not subject to public knowledge. Next slide, please. Thank you for your time. Anybody have any questions for the last half here?
Awesome. Well, thank you, Mr. Roberts. Thank you,
Of course.
Mr. Riley. Just one quick note for everyone regarding the rulemaking that the Public Utilities Commission is undertaking. Just to be clear, I believe, and correct me if I'm wrong, Mr. Roberts, the statute says that the commission will consult us on any rulemaking regarding to rate setting. This rulemaking isn't directly related to rate setting. It indirectly reduces some revenue and some rates, but it's not a direct rate setting rulemaking. And so there's a good chance that the PUC will not consult us on it. And that's okay. So we don't need to insert ourselves if the PUC does not ask for that input. That doesn't preclude any members from individually submitting comments during the rulemaking process, but as a task force, we're not going to like proactively do that unless the commission asks us for our input. At least that's my understanding of how it'll work. Mr. Riley and Mr. Roberts, let me know if that's not correct.
That's correct.
Awesome. Mr. Pierce.
Thanks. I have a couple of questions that continue to I mean, I'm continually sort of boggled by them. One is the ex parte advice, and I'm just wondering, first off, where the legal source of that requirement is coming from, if it's statute or if it's just advice, legal advice, or quite what. But one of the things that has been very unclear to me from the beginning is the extent to which we can have conversations with constituents who we are nominally supposed to represent. So Trevor and John having conversations with other towers, listening to their concerns and so on. And in my case, listening to manufactured homeowners who wish to weigh in and express their concerns. And then in our representative capacities, we can bring those to any kind of a task force discussion. What I was led to understand, I believe, from last year was that is restricted or forbidden from us because of the ex parte advice. And then one thing that came up last year was an invitation to a meeting of towers where it seemed like the advice was it would be fine for us to attend that, even though it struck me as that was a classic example of ex parte, if we weren't able to meet with our representatives. So that's question one. I'm just trying to get a better sense of the boundaries of ex parte and also the force of it, where the legal source is coming from. The second one is on conflict of interest, and it just strikes me as we are just flat out in violation of the conflict of interest. The committee, the task force makeup, we've got people, almost all of us have conflicts of interest according to the definition. And so, because that just seems like it really comes with the makeup of the board and how we are actually, or of the task force, and how we are actually assigned. I'm rather baffled about that. John and Trevor, for example, have very clear financial interests in any of our recommendations with regard to rates. So I guess I'm having difficulty seeing how that is something that we are to abide by. Thanks for entertaining the questions.
Sure, I can respond to that. So with respect to the first question, Michael, I think the restriction on ex parte communication really depends on what the substance of the conversation is. If it is something to do with specific issues or matters that the task force is handling, you have to remember that by saying, hey, the task force is doing whatever you say after that, you're speaking for this entire body without this entire body's input. So you need to think about it like that. Would Trevor and Nate and Jeff and everybody else, John, everybody else that's here, would this be something that all of us need to hear about? One person going out and getting information, like yourself, getting information from a constituent and bringing it back, that's a violation. It's all about proper channels. So if an individual that you're speaking with has an issue, the proper way to do it is not to use a task force member as a conduit, but to use the proper channels to, hey, I'm a constituent, I'm a member of the public, this is my concern that I like the whole task force to consider. But if one of you has that conversation about a task force business, some task force business, that's the difference. That's the distinction. I mean, you can talk in generalities with people that you deal with, your constituents, neighbors, whomever. But if you are talking about things that we should be talking about as a task force, that's where I see the distinction. On your second question, the conflict of interest question, the statute, because the statute specifically creates this board, it's understood that the General Assembly understood that there was a potential for conflict of interest, but there's also an expectation that members of boards and members of commissions and task force, whatever you have along within the state government, are acting in good faith, wearing the hat when they're in this business, wearing the hat of looking out for the consumer. So when Trevor and John Connolly are here, they're not towers. They're here as members of the industry. We're here to look out for the general public. And part of my job is to pay attention to make sure that when we make decisions or when there's conversations, that we are staying within that lane, wearing the proper hat about looking out for the public and not looking out for self-interest.
Okay, I guess the follow-up on that is that kind of goes contrary to the recusal as the standard way of dealing with it. Rather, that sounds to me like the main way of dealing with it is disclosure, and I think good behavior, so that we all on the board recognize each other's interests and hold each other accountable to that.
Yeah, that's exactly right. So one of the other boards I represent, and I bring this up by way of example, is the Passenger Tramway Safety Board. So that board regulates ski lifts and gondolas and rope tows, all that jazz throughout the state. And on that board, the statute requires that a representative of lift manufacturers is on there, and that a number of industry people are on there. So we've had a CFO of Vail on the board. And when a complaint, and they deal with complaints. They deal with complaints from skiers or variances. And when there's a complaint from a skier about, say, Vail, and there's a Vail member on the board, that person recuses from that conversation. They can't participate in that because they have a financial interest in the outcome of that complaint. So when it's a specific issue about a board member's business, that is where recusals have to happen. So if this task force were to consider complaints from the public, and someone filed a complaint against the company Trevor works for, I'm sorry, Trevor, I don't know who that is. If they file a complaint against Trevor's company, or Trevor in particular, that Trevor would have to recuse. I would advise him, you need to recuse from this conversation. So we would all talk about the complaint, and Trevor would sign out, and when we're done, he would sign back in, and we continue with the meeting.
Is that adequate explanation, Mr. Pierce?
There's still, I mean, that particular matter, I'm still, there's a gray area for me, because we are making potentially recommendations for rates, and two of us have direct financial interest in what those rates are. That just does still strike me as at least the way you just described it, Mr. Roberts, it sounds like that would be a case where recusal is needed. And that's what I'm still trying to wrap my head around. But I guess I'm okay with it. I mean, it seems to me like the way we're dealing with it is through possibly a balance of conflicts of interest rather than recusal.
That's a good description. It's kind of a balance. I mean, because we this task force, the tramway board, whatever it is, they depend on members of the industry to provide insights for the work of the task force. So we benefit from Trevor and John Connolly's inputs, their insights into what the business is, and we balance that benefit against the, as you described, the conflict of them being within the industry. So it's definitely a statutory balancing act.
Okay. I'll leave it there.
All right, thanks, Mr. Pierce. Okay, if there's no other questions on those items, I'd like to open it up for anyone who has any thoughts or ideas or discussion regarding kind of what our goals and objectives should be in 2023. So I'll start with one. Actually, Mr. Pierce, you go ahead.
Okay. Just to pick up on where our conversations left off shortly before producing the report, I had a number of items that I thought that we had slated for this year. And one was that we had punted on making any rate recommendations. So it struck me that we had committed ourselves to actually trying to develop some rate recommendations. And so I think it would be good to think through that. Another was that we had a goal of doing a relatively thorough analysis of the relationship between the statutory rates or the public utilities rates and market rates. And so I believe we had wanted to engage in that, and my understanding of what John had provided into the report was that was kind of a start of trying to look through why market rates differ from non-consensual rates. And that was a good starting place, in my view, for really doing a much more thorough analysis of the relationship between the two as a task force, as the body, versus something that was assigned to just John to produce. Let's see. Some other things also that seem to be needed on the agenda are on this year's work list, so to speak, is that if we are going to look at the rates, one of the things that Joanne had brought up was that we've been relying very strongly on Utah's study. That was a study that grounded the prior task force's study, and Joanne brought up that there's quite a few other states that have different rates, and she also brought up some states that have considerably lower rates than I think what we saw in the Utah study. So I was thinking that it would be very good for us to try and engage in some research into other states' rates, just to get a good comparison of where Colorado's rates are. So those are agenda items that I have listed, and I would appreciate us working on.
Yeah, thanks, Mr. Pierce. And one other item to add that I remember we discussed that I think could be an achievable item during the year is analyzing the applicability of the CPI print to adjust rates and to see if there's some other metric that's readily available that might be more applicable to this industry. So that's something we might be able to do as well. Anything else anyone wants to discuss, or any thoughts on the items that Mr. Pierce just talked about? All right. We can adjourn the meeting early if we need to. I know we're all hungry, I'm sure. Mr. Riley.
I guess I just kind of wanted to comment that, I really do hope to have, pretty heavy involvement in this task force moving forward for the rest of the year. I know we've already passed our statutory deadline for that first report. And again, it's not even identified as a first report. It's identified as just a report, maybe some kind of subtle indication that that was the only one we were going to submit. But I think everybody, especially during our meeting back in October when we finalized the report, everybody seemed like they had that interest to continue moving and continue working and continue looking at these issues and analyzing things. Maybe it'll be a little better now that the, quote unquote pressure's off. We don't have a statutory deadline to meet moving forward for any additional reports, but I do still think that the commission can get some good use out of whatever this body puts together moving forward. Obviously, we have the report that we've submitted, so that's something that will be officially addressed by the commission in an upcoming rulemaking. But I hope everybody still maintains an investment in this board and their appointment to it to represent the different communities and interest groups that we all are supposed to be representing. So anyway, I just wanted to call that out, that I'm hopeful that we can continue to work and analyze all these different issues. I did like the idea of looking at other states. I agree that a lot of the rates that are on the commission books right now originated with that Utah study. So maybe looking in other areas. One little comment I would make to that is I do recognize that Colorado is a fairly unique state, and you can never really draw direct comparisons from one state to another, especially when Colorado is that other state. But anyway, it's definitely an idea I think is worth pursuing. Obviously, a lot of different states handle towing a little differently than we do here. And again, just given the uniqueness of our particular state, we'll have to take all that into consideration. But I definitely think that can be a useful exercise. I agree with Trevor's comments about exploring the CPI and potential alternatives that may be more appropriate. I would assume the commission would be open to at least hear that argument if there's one to be made. And then the other thing is, I know one of the things that we put in the report, which again, I don't know if we need to go any further down this road, maybe just keep it as something in our back pocket to continue to bring up in any potential future communications with the commission, is the desire to have certain additional data be gathered by the commission for towing carriers. Such as demographical data or particular, operational specific data, such as what types of tows they're performing, to get a better gauge of kind of how that all spreads out across the state, not only in different areas, but also, in the Denver metro area as well. So I think that can all be helpful. And I'm very anxious to see, where we go the rest of this year and moving forward past that.
Mr. Connolly.
I've had a few conversations looking at the complex industry and looking at how many rules there are and how many complaints they have, and going through all this I don't know what you call it, trying to figure all this out, right? As a board looking to regulate an industry. Why don't we look at it as free? What if we suggested a free, any non-consensual tow done is free to the consumer? I mean, it was a suggestion brought up, and it makes a lot of sense. If it's free to the consumer, then it doesn't need to be regulated. Don't have to go through all this rigmarole, and you let the free market fix it. Just like everything else, free market takes care of itself.
It's I guess a valid question. I'll turn over to Mr. Pierce, but kind of for the group, just, I guess, a thought exercise, right?
Yeah,
Sometimes-
exactly.
Mr. Roberts knows, like in legal stuff, often you look at extreme cases to kind of like hone in on stuff. And so a thought exercise might be like, maybe the case is you could make a regulation that non-consensual towing, law enforcement, private property, or just private property or whatever, just by definition has to be free, that the towing companies cannot charge for that service. And so maybe we should think through that of it. Maybe that's an option, right?
I'm talking all. I mean, my suggestion, I know someone said to repeat that. All non-consensual tow is free to the consumer.
Any
Okay.
thoughts on that?
And
to the group?
because if you look at the industry in itself, the industry is a service industry, right? They're providing a service. The towing industry does not say what needs to be towed, why it needs to be towed, or anything. They're the ones that are called to do the service of whatever it is. Clear the parking lot, clear the street, clear the river, doesn't matter. They're there to perform a service. So what's the difference between snow removal? Okay. The snow's got to be removed from the property. It needs to be removed from the city streets. It's something that's impeding the traffic for safety. It just, and if you look at that, free market takes care of all those issues. Look at your lawn care services. Look at anything. Service is a service. So instead of trying to regulate and try to regulate a service industry, we'll let free market take care of it. And I've had towers come to me and say, well, that's a good idea and it's a bad idea. Well, how is it a bad idea? If you call someone and say, hey, I need the snow removed from my driveway, and you call multiple companies, they're going to give you a price, right? Isn't that consent? It's a free market. You pick what price you want to use. So what would be the difference? Let's just put this in and I'll put it in two scenarios for you. Let's call it a private property. Private property has a parking problem. They want cars removed for whatever reasons it is. No difference than they want the grass cut at 3 inches or 4 inches, or the snow removed. It's a service that the tow company would be providing to the property owner. Therefore, the property owner would pay it no different than he'd pay the snow removal or the lawn service or whatever. Okay. If law enforcement calls for a tow and they want the street moved, the cars moved out of the street for public safety or whatever, here again, they can contract with a tower that gives them the best bang for their buck. And then that eliminates 90% of all those problems. So brain exercise, food for thought.
Mr. Pierce?
Thanks. My hand wasn't raised for this, but there's more to follow up on Nate's comment about the PUC registration and survey. But I'm happy to weigh in on this.
Please do.
The first thought is that let's see, there are two property owners typically in this instance, right? You have the landowner who is calling for the tow, and then there's the car owner whose car is being towed. And so one party is involved and in property rights and in economics, we often talk about third party effects. And so just giving the leeway to tow a car without involving the interest of the person whose property is being towed means that you're giving a right to do something with that piece of property without addressing that third party's concerns. So that automatically brings in some issues that just need to be addressed because there's still a non-consent element in there, and free markets work based upon consent. The second part is that the question is an intriguing one because obviously the towers have to get paid somehow, and the analogies that were just brought up were seem to be suggestive that the landowner is going to be the person who's purchasing the tow. And so the financial responsibility would be on them. And then question would be, how do they recoup their costs for doing so? And then there's a variety of ways that they might do that. That sounds to me like an interesting thing to think through, because the landowner is probably going to recoup their costs through rent of some sort. And then finally, there's a question of incentives here, and free markets work well when different people's incentives are incorporated into the decisions. And again, we have questions about whether the tows are done in a way that is reasonable and fair. And if there's an incentive, if the only contracting parties are the landowner and the towing company, and there's incentives are the ones that are at issue, then the person whose car is being towed, it's very hard to determine whether or not the incentive works in favor of their interests, or whether their interests get incorporated as part of these incentives. So interesting thought questions, but it feels like some very important interests end up being left out of how decisions get made.
Mr. Riley, I think you're up next.
And I definitely can appreciate your comments, Mr. Conley. And yeah, I enjoy these thought experiments and these theoretical scenarios and stuff. We hear it all the time at the commission. In fact, it's one of my favorite parts of the job is, people will call in and, you think you have the regulations down and you know exactly what limited guidance can be given and rule references can be provided to get the towing carrier on the right track. But inevitably, there's always some little wrinkle, some other little aspect of a particular scenario that makes you rethink that particular regulation, rethink that particular guidance. And so, I enjoy those thought exercises, and this is certainly one of those. The first thing that popped into my head with the discussion of the concept of just making non-consensual tows free, the very first thing that popped in my head is, then what's the deterrent effect on the tower if they're not actually paying for anything? What's their incentive to follow the parking policies? Why wouldn't they just park anywhere? And yeah, it gets towed, and maybe it's an inconvenience to go get your car after it's been towed. But if there's not a financial deterrent effect to it, I don't know. That was the first thing that popped into my head. So anyway, that's what I had there.
Andrea?
Yeah, I do agree. That's an interesting thing to think about. So, obviously we work on policies around landlords, and one thing that has come up a lot is fees and landlords profiting off of valet trash fees and common area maintenance fees. And, according to consumer protection laws, a fee has to pay for what the service is, but we've seen it all over the place that landlords just do profit. And one of the trash valet companies that we came across market themselves as basically take our service so you can increase your bottom line. And so there's just a lot of evidence that landlords are profiting off of fees and amenities and things that they charge. And so I would worry that, landlords would either say, this is just a fee that everybody pays, but there's no guarantee that it's actually paying for the service or it's actually amounting to the cost of the service. Or, when a car is towed, how would we know that what they're charging? Because there's no way in hell landlords wouldn't just charge the tenant. And that could probably be in their lease. If you get towed, you get charged this amount. So how do we know that it's not being, ballooned for additional profit, which would mean they have incentive to tow even when maybe it doesn't make sense to tow if they're profiting. So that's kind of how I see that happening. I mean, theoretically, I think that's a interesting idea, but I think the way it plays out is like every other service that landlords provide.
Mr. Hahn?
Yeah, thank you. And that's one of the favorite parts of my job as well, with my regulatory obligations with the trucking industry, is these discussions that we have. With respect to this one, yeah, interesting idea, and really good discussion. And the thing that comes to mind for me from a law enforcement perspective or public safety perspective is then when you're talking about landowner bearing the obligation, the financial obligation for a non-consensual tow. What does that look like when that landowner, quote unquote, is a public entity? Whether it's CDOT, who owns the road, it's a state or interstate highway, it's a county that owns a county road. What does that look like? And the obvious question there is then, how would something like that get funded? I could see the need for whole other mechanisms within state and county government and city government, within a public safety entity, just to manage the contracts that would have to happen with different carriers. Most often this happens. In fact, I had it just this morning on the way into the office, a crash that happens in the middle of I-70. You've got two vehicles that are disabled, and it's a public safety issue to keep the road blocked. So we just need to get them moved. And so often in my world, we call for tows, to get the vehicles, to get them off the road, and that insurance will handle that. And I'm saying that to not to be cute, but that's the thought process. Is that'll get handled. We just need to get the road open so we don't have residual crashes. We don't have people standing out in the middle of the highway. So it's a great question, and those are the first things that pop in my mind is how that would work, how that would be managed, and what sort of funding mechanism would need to be in place in order to manage something like that at a state, county, and local level. But, a great question.
And thanks, Mr. Hahn. Yeah, I think I guess this highlights, why it's a regulated industry. Like, it's challenging, right? Like, there's competing interests here. There's incentives and disincentives that are very challenging. To go to one extreme to say, like, okay, well, I guess there's two ways you could say. You could say it's free, so you do regulate it, and you say that, like, look, like if a car is towed non-consensually, it's free to the consumer that owns the vehicle, and how the tow company gets paid is someone else. The market will figure that out, but it's free to that consumer, right? Like, you could make a rule that said that. As some of you kind of touched on, it becomes quite problematic in a lot of ways. In one sense, let's say there's a wreck. Mr. Hahn has to get a wreck cleared from the road. Effectively, the police department is going to have to pay for that, or it's just not going to get done, right? Or the police department can have their own towing service. Those are the two options. That effectively the police department has their own towing service, which I don't think most law enforcement agencies would want to get in that business. Or the law enforcement agency pays the tower for that service. But remember, the public pays for that service. Like, the law enforcement agency gets that money from somewhere, and so it's just going to end up in higher taxes, which may be okay. I'm not saying that's the bad thing, but just know that it's not a free lunch, right? Just mandating something doesn't cost anything doesn't make it not cost anything. And so at that point, what you're doing is you're the person who got in the wreck, right? And most often their insurance company, instead of them bearing the cost, then that cost becomes diffuse and is bared by the taxpayers that fund that law enforcement agency, which may or may not be a good system, but just know that it's not saying it's free doesn't make it free, right? And so that could be something to be looked at. On the private property side, similar things that you could say it's just free, right? Like, the car owner doesn't pay for it. And then the only option really is for the property owner to pay for that service. And that has a couple challenges, I think. One is, to Nate's point earlier, then at that point, there's no disincentive for anyone to not park in a handicap spot. For example, there's very little disincentive for someone to clear fire lanes, or frankly, just to not park there if they don't live there and they're supposed to have a permit, or they're in someone's reserved spot, right? Like, there's just no disincentive there. Now, let's say you did do that. The property kind of has a couple options. They could just increase rent a lot, right? for everybody, and then everyone would kind of end up paying for that service. Or they could charge the actual tenant, as Andrea mentioned, would be a concern. That I think that would be a concern and could be very problematic. I agree with that. Also, another trick is often the person who got towed is not a tenant. In fact, that's often why they got towed, right? Like it's a parking lot that is reserved for tenants, and you have permits, or you have to buy a permit, and people don't. Well, the property owner can't pass that through to the tenant because that person, by definition, is not a tenant, right? So that's become a problem. One thing I think you cannot do is basically say, well, we're just not going to regulate the rates at all. Because in this sense, and this goes back to what Mr. Pierce said, it's unique in the sense that the private property owner has rights, but the car owner does too. And if you have that car and it was impounded, it cannot be that you can charge whatever you want to. And there's been markets actually in the past that have been unregulated, especially around heavy towing. And it turns into a disaster because then you have very bad actors in the towing industry that, the market doesn't figure it out because I have your car. And we're not going to allow you to get it unless you pay whatever price we decide is fair. And so that's certainly not an option, I think, for anybody. But, making it to where consumers can't pay, I think, is an option we should consider. It's not done that way anywhere in the United States at the moment. But I'm curious to hear any pros and cons that people might think about that option. Mr. Connolly.
Well, and the reason I say this is to get everyone's brain in the right direction here. Like State Patrol, they're clearing the roadway. They're looking at that as, get the roadway cleared. Let's not get anybody hurt. Safety's first. Life is more important than any object. Get the objects out, get everyone safe. And the assumption is that they have insurance. And so the assumption is that the tower is going to get paid. It's no different than private property. You tow vehicles off private property on the assumption the tower is going to get paid for his services. And what we all have to remember is the tower takes 100% of the financial risk in this. No matter which direction you're talking about, law enforcement, private property, it doesn't matter. The tower is taking the brunt, the 100% financial risk if the vehicle gets picked up. I mean, the problem is we forget about all of the stuff that doesn't get picked up. We forget about the stuff that's dumped on private properties, abandoned trailers full of trash and junk. State Patrol is the same thing. How many vehicles have you towed off the road that are just junk, right? That no one's going to pick up, and they don't pick up. I mean, there's times where you guys actually have to issue a junk letter because there's no VIN numbers or anything even to process the car legally. So the brain exercise is twofold. Consumer is a goal, yes, but the service provider is also the goal.
Mr. Hahn?
Yeah, when I mentioned the tow company or the tow companies and dealing with insurance, that is the common perception, I think. And to be clear, I'm under no illusion that every vehicle that gets taken to a lot is dealt with by an insurance company. And for those that don't know, we have a whole mechanism inside of the State Patrol staff that's just dedicated to dealing with processing abandoned vehicles, a vehicle that was towed out of the road for whatever reason as a result of a crash or as a result of whatever, and it's just never claimed, it's never paid for, and so we have this whole mechanism inside of the agency that just deals with tow companies and processing those as abandoned, so that then there is some hope of recouping something. Point well taken. We know very well that stuff that gets taken off of our roads as a result of our tows, the tows that we call for, is often just left abandoned, sitting in a yard.
So continue this thought experiment. I'm curious if anyone believes that regulating tow rates to zero for the vehicle owner. I guess that would be clear for the vehicle owner. Does anyone think that might be a legitimate option, that might be a better situation than we have now? I'm just purely curious if anyone believes that might be the case.
I do. I do in certain situations. Recovered steals. We are the highest in the nation right now in recovered steals. My company alone probably impounds 5 to 8 a day in the last 60 days of recovered steals. Most of those people don't have insurance. And we have no programs set in place to provide the service for the cities when they recover the vehicles, to get them secured into a secure location. And then the owners of those vehicles don't have insurance and they have no means to pay for the services to recover the vehicle. Those are situations where we've got to come up with something in this state to fix that. I suggested bringing back the old, you stole a man's horse, you got hung. That would be a great start. We can start there and just consider cars as horses, and maybe that will stop some. But on the other side, the true thing is the victims. So, and I've heard this argument, victimizing the victim. Well, the towers are not trying to victimize the victims, but should the tower automatically become the victim? That's the other part. There's got to be a way that the tower can at least provide the service. They can't provide the service for free because they have expenses. But on the other side of the coin, you have a victim who has truly been victimized, shouldn't be penalized as well. So there's no mechanism set in place to protect those types of things.
Mr. Riley?
I definitely can sympathize with what everybody's saying about that. It's, the whole auto theft aspect and the fact that somebody can be put in a absolutely tough situation where their vehicle has been stolen and then it's abandoned, on the other side of town or whatever the case may be. And then law enforcement finds it, it's in the system. So they find it and they designate it as a stolen vehicle. Yeah, that's typically their recourse is to have it impounded, and then the person whose vehicle it is has access. But at the end of the day, the towing carrier impounding that vehicle at law enforcement request still has to be compensated for their time and their resources. So it's a terrible situation, and I absolutely sympathize with it. I know I've heard some things about. I think the city of Aurora has come up with some kind of a program whereby it's going to be city funded in some way or another. That something like that might work. I was actually just talking about this particular situation the other day, and I think I mentioned something about and again, I don't know how realistic this is, but for officers, finding a vehicle that they know is stolen, maybe there's something in the system and you have the person whose vehicle it is phone number and give them like an hour to come pick it up so it doesn't have to be impounded. Again, I don't know how realistic that is. I know law enforcement, they have their own issues with personnel and resource and time management and stuff, so maybe that's not realistic. But yeah, no, it's a tough situation, and I don't know what the answer is, but I definitely can sympathize with that kind of a scenario where not only has your vehicle been stolen and you haven't had access to it, or maybe it's been damaged, maybe they crashed it and just abandoned it on the side of the road. So you're already in a tough situation based on that alone. But then if you had a potentially expensive tow bill on top of that, it's even more of a problem. So yeah, I don't know what the answer is, but it's a tough situation.
I can inform everyone that if a car is stolen and is recovered, is towed from private property, that car does get released back to the car owner for free. I don't know if there's a rule or a law that says it, but the police departments tell us to, and we just do what we're told. So I don't know if there's a rule in the books, but if a stolen car ends up at a private property impound, it just is decreed by the law enforcement agency that you shall release this, and that's what happens. On the law enforcement tows, which often are from public property, right, roadways, that one gets a little bit more tricky, and I think that's what you're referencing in Aurora, that they're looking at and doing something with that, and I hope they do. All right, Mr. Pierce.
Thanks. What an alternative that that has been one I've been trying to think through, and I don't think I have all the pieces in place, because there are too many different kinds of tows to track. But I want to say there are two rates to be looking at. One is the rate charged to the non-consenting consumer, and the rate that is reimbursed to the tower. And on the consumer side, it seems like there definitely needs to be a disincentive involved. So somebody who's parking somewhere where they shouldn't be, there should be a cost to that, so that they are so that it's not free and you can park anywhere you want, and there's no financial penalty involved. So it seems like there needs to be some penalty. But the problem is that a penalty that's high enough to disincentivize is much lower than the cost of actually paying the tower for their costs. And so I'm thinking, for example, that a reasonable fee to the non-consenting car or truck owner could be set based upon just trying to think of the way we ticket people for speeding or for other kinds of infractions, and set the fines high enough to be disincentivizing, right? But no more than that, so that we're not over penalizing people. And then that fine could recoup part of the tower's costs, but then the remainder of the cost would have to be borne somehow, either by the public or by the landowner who is scheduling the tow. And it strikes me that if there were this shared cost model, the landowner would have to think twice about doing this, because right now there's almost no incentive on the landowner to refrain from frivolous tows. So if the landowner has to pay for each tow, they have to think twice about whether they're going to do it or not. And so this shared cost model, I think, where you can charge only so much to the consumer, but the tower can recoup the remainder of the cost from the landowner who's calling for the tow. That strikes me as a much better model, and I think the free market then would handle how much the tower would be able to charge to the landowner who's calling for the tow. And I think the rates would naturally work themselves out through a free market, and we would also resolve the problem of overcharging the people whose cars are towed by both getting a rate that's high enough to be disincentivized, but not so high that it's really creaming them financially.
Okay, thank you. And this is a perfect segue. Mr. Rich has many years of experience in this area. So, Mr. Rich.
Well, I mean, I think from the whole discussion, it kind of goes back to your comments of like, okay, so it's going to get paid somehow, right? Even these cars that are stolen, and you say you return them, and they tell you to return them for free, and so you guys return them for free, but actually it's not free, because if you had to return more of those cars than you make profit with everything else, you'd be out of business. And so somehow those costs get rolled into other services. And so I mean, I think the challenge I see with the kind of public paying model through taxes in Colorado specifically is, they'd have to generate more revenue. I think right now you have cities in the state that has revenues because they've, been allocated a lot of dollars here recently through the federal government, but those dollars won't always be there, and the economy won't always be the same, and they can't raise taxes because of Tabor to actually cover that. So they couldn't pass a special tax to say, hey, we're going to do this towing tax. It'd have to go to the people. And so that would make it a little bit more difficult. I think regarding the private property tows, and to Dr. Pierce, one of the comments that in general, the apartment owners specifically, where you have these tows, I don't think that anybody You know, and I know there's always exception to the rule, but I don't think the property owner, even though they're not paying, has an incentive to do frivolous tows. And that's because our consumers are our residents. And so when we tow, it's a bad situation for us because we don't generate any revenue off of towing. And I don't know any property owner that generates revenue off of towing. And so when we tow, essentially all we're doing is upsetting one of our customers. And the only reason that we tow is because we either have an obligation to keep, you know, through safety of fire lanes and stuff like that, or, you know, we're trying to police the community. And so somebody is violating a policy and they're taking the right of another resident. So for instance, if you park in another resident's parking spot that they're paying for, the one who, whether it's a resident or a guest, they're violating another resident's policy. So at that point, it becomes more advantageous to us to protect the resident that's abiding by the policy over the one that is breaking the policy. But just to tow, I mean, I would tell you that if there's a tow that is frivolous or even for some good reasons, I mean, Trevor does work for us and their company returns a ton of cars for us because we call them all the time and say, hey, we made a mistake. Can you return this? Or hey, you know, this person did this or had this, and they return cars all the time. So there's not really a built-in incentive for property owners to tow. But, you know, the people who buy these apartments, I mean, I know a lot of times is thinking, hey, it's just these, you know, kind of fat cats, but really who's buying these these are funds. A lot of times it's the state workers pension fund. It could be the para who's investing into these properties, and they're not going to invest in the properties unless, you know, what their expenses are. They're making additional income. It doesn't matter if it's a fee, doesn't matter if it comes in form of rent. I mean, it's an investment. And so, you know, if you just add an expense, what happens is people won't invest in the properties, which means that people won't build the properties because they're investing in for them to build them if there's not a fee or a market for somebody to buy them. And so then the housing goes away. So, you know, eventually if you put caps on rents or, you know, add in all these fees and they're not covered by rents because, you know, the rents are going down, then that's when you get in a situation where you have like a not sufficient amount of housing. So then you have to have the state build the housing because capital won't build it. Just private capital won't build it.
Thanks, Mr. Rich. See here. Oh, no hands up, but I got a question for Mr. Riley. I mean, it's obvious that the issue here is there's competing objectives, right? When you're regulating this stuff and you're trying to find a balance between those competing objectives, right? Like at one end, you want tow companies to exist and function because there's a necessary service that they provide. But on the other end, you also can't have people getting charged, you know, $1 bazillion every time they get the car towed, right? That you're competing on those things. From your perspective, Mr. Riley, or I guess from the regulator's perspective, like what is it you're trying to optimize? Like what is it you're trying to balance? Like what would you state your objective is in regulating towing or any other industry that has similar dynamics?
I think the way you stated it captures it fairly well, and it's something I tell people all the time is that the commission is essentially responsible for making that balance, because as you stated, you know, towing carriers, there is a need for them. You know, otherwise you just have abandoned vehicles all over the streets, all over private properties, and you know they just stay there forever until I don't know, whoever comes along and moves them and rolls them. But all they're going to do is roll them somewhere else, and then where do they go from there? So you know, there is a need for towing carriers. You know, I'm sure Captain Hahn would advocate for there being towing carriers existing for rolling vehicles out post crash and everything else. But at the same time, again, putting it in a position where, you know, people don't get gouged. You know, people can rely on the existence of those services without having to suffer unreasonable, you know, financial challenges as a result of those services, especially in instances where they initially had no say in those services occurring, which is what non-consensual tows are. So anyway, that's how I would define it. Is that's what the commission's job is, and what our administrative law judge, you know, they're exploring all of these issues, and that's why we rely so heavily on commentary that we receive from the public and from other people who are involved, stakeholders and such, during our rulemakings, to give us some guidance on where the industry thinks these fees should be, where the public thinks these fees should be. Obviously, they have, the SMEs here on staff, myself and other people in the transportation staff, where we can provide some guidance as well based on what we're seeing, what we're hearing in regards to the industry and how everything works. So, yeah, that's what I would say to that. Is it is the commission's job to basically find that balance to the best way possible. And again, it's always moving because there's always new factors to consider. Obviously, with the new legislation, that's something they're going to have to consider in this upcoming rulemaking that's going to be coming up here shortly. So yeah, they have to take everything into account. The judges do it, the commissioners do it. And again, at the end of the day, you make the best decision you can based on the information you have. It's not always perfect, but it's usually the best decision that can be made on that time based on all the available information.
Yeah. One thing, this is anecdotal, but it might be helpful to kind of think through it. Because we have some businesses in other states and stuff like that. And so I've seen different models in different places. Some are good, some are bad, it depends. But there's one area that's in Texas. It's a major metro area. In Texas, it's a little weird. The state regulates the maximum rate, just like the PUC does here in Colorado. But the municipalities have the ability, and often do, regulate rates lower than the maximum, right? It's as if, we have our state rate here, but then the city of Aurora decided, no, it's going to be $10, and they can do that, right? The major city in that metro area, for whatever reason, has not increased the rates for maybe like 23 years or something. And so that rate is dramatically lower than the surrounding areas. And so it creates like a natural experiment to see like, okay, what happens when the rates are super low in one area and there's an imaginary line on the other area? They're what I would call normal. And what ends up happening in that major metro area, because the rates have gotten so low, it creates an environment where the cars still get towed, but there's a different type of tow operator that chooses to operate in that market. And that's the kind of tow operator that, like, it's usually they have like one or two trucks. They operate out of their house. And if they often don't, they will carry insurance, file it with the regulator, and then cancel it the next week. And then they're good for a whole year because it's on file, right? And if they get caught, they shut down the company and open up another one in their wife's name or their cousin's name or their kid's name or whatever. And then they restart the whole process again. And there's a ton of them, and they're everywhere. And those folks at that really low rate, not doing things the right way and not obeying the rules and not having correct insurance or training for the drivers or safety procedures, they can turn a small profit with that rate. But the larger operators who have requirements, right? Like they have safety procedures they must follow. They have, they can't just not have insurance, and they have to train their people and all that kind of stuff. Those folks can't turn a profit, so they don't do business in that metro area. And so you have a situation in which in one area, the rates are really low, but frankly, there's a lot of tow operators that run around literally stealing cars, towing, like they'll take toilet paper rolls, roll them up under the car, like horizontally, and then take pictures because it looks like it's a stripe and it looks like the person's double parked, and they'll tow the car. And those people will operate that, and at that tow rate, they can turn a profit. And I guess that's like a cautionary tale of where you get, if you say, okay, it can't be zero, but let's make it $10 because it kind of feels more fair. It's one of those situations where you kind of get what you pay for, right? Up until a point. And that's where the challenge comes, because at the other end of the spectrum, everyone would probably agree that the average tow operator should not have like 70% profit margins, right? Like that's not a reasonable profit margin for most, industrial type businesses to have. And so finding that balance, but forcing it too low does have consequences. The question of how low is too low and how high is too high is what our job is to kind of try to think through and figure out. But as you move it down, you start to get into a situation in which the people that are performing the service are not the people that it's in the best interest of the public to perform the service. Sorry about that long-winded answer. Mr. Connolly. Hey, John, I think you're on mute.
I think I am on mute. Thank you. The problem that I've been having is trying to lower prices to help people when expenses go up. Just towing equipment went up $35,000 this last year in 22. From the beginning of the year to the end of the year, the same exact truck spec the exact same way went up $35,000 in 1 year. January 1, it went up 8% from the towing manufacturer. So I see nothing coming down anytime soon. And if the expenses don't come down, it's very hard to get the services down. Just food for thought.
Thanks, John. All right, we've got about 10 minutes left. I want to know if anyone has any other thoughts on what our objectives are. What is it we're trying to do here? Anything? Mr. Pierce.
I wanted to pick up on the original reason why I raised my hand before John posed his thought experiment. Was Nate brought up the registration scenario and the ability of us to potentially get some survey questions moving as part of the registration process. And I wanted to just put in my own recommendation for us to actually come up with a proposal for questions that we think would be usefully included as part of the registration process, so that we can start collecting data by which we can really do rates better than, have a better representative sample of the kinds of questions we were trying to get answered in our current survey, but with a really low participation rate. So I thought it would be really good to try and work out survey questions that we could recommend to the Public Utilities Commission to include in the registration process.
Okay, thanks, Mr. Pierce. Mr. Riley.
Just in response to Dr. Pierce's comments, I totally agree. And we wouldn't even necessarily have to structure it like we did with the survey. That had a very clear purpose, whereas this would be kind of a different methodology through which to gather information. But I think we could come up with something that kind of falls in the middle there somewhere. The other thing I would note is that I have a feeling the commission would be very receptive to any ideas we come up with, just because there's some certain department-wide initiatives that have been for the past year filtering their way down to our different respective divisions, and it all has to do with demographic type data. Just kind of putting ourselves in a position where we can use our authority as the regulatory body over these respective industries, and not just transportation, across the board, all the industries that our commission regulates, and ways to potentially use data, one, that's already available, and two, exploring areas where additional data could potentially be collected to reach not just conclusions in a forum like this, but other forums as well. And so like I said, I think if we came up with some type of a list, again, it wouldn't necessarily have to be in a survey type format, but just maybe just saying to the commission, listen, as the towing task force and what we're tasked to do, and in the interest of coming up with better rates for across the board for the industry, et cetera, we feel it would be helpful if the commission collected on an annual basis, or in whatever format the commission finds appropriate, these different data points. And again, I think we can refer to the survey we use to kind of come up with what those data points are. But yeah, no, I think that's a great idea. And I definitely think we should kind of start thinking about that and brainstorming what we might want to put on that list. So thank you, Dr. Pierce.
Nate, one administrative question. The proposed rules that staff will be working on, while we may not be solicited for advice, is that something when it's ready, like the red line version, that you'd be able to distribute to the task force as well?
Well, when it gets introduced, it'll be public to everybody. So yeah, no, we'll have access to it. And again, it's going to be, I think, kind of, in certain respects, I think it'll be kind of a lot of what people kind of expected based on the new legislation. We didn't really deviate a whole lot from that. But yeah, like I said, there should be something hopefully on record by the end of this month, or at the absolute latest, first thing next month. So okay. At least that's the current schedule that I've seen.
Okay. If anything doesn't preclude us from sending it via email, I mean, I'll obviously get a hold of it, but the portal for getting stuff is somewhat cumbersome. And so for some of the other members, it might be a little difficult for them to sign up and get all that stuff and sort through all the junk on there.
Mr. Roberts, would there be any concerns with me just circulating a copy of the decision and the attached red line once it's available, once it's public? Do you see any concerns with doing that?
No, sir.
Okay, I'll just plan to do that.
Cool. Awesome. All right. Anyone have any last minute items before we go?
Just one last comment. Again, just as a reminder, Captain Hahn, I'm going to be sending you a copy of that compliance affidavit. If you could just please review it and sign it and return it to me, I'd appreciate that. If you have any questions, just feel free to email me and let me know what those are. And then everyone else, like I said, I'll double check and see if the compliance affidavits we signed last year are still good moving forward. I just took a look at it earlier during the meeting, and I think it might still be good, but I'll double check that. Definitely let all you know. Thank you.
Awesome. All right. Thanks, Nate. Okay, everybody. We will see you. We do the second Tuesday every month, right? Or am I confused?
So that would be the 8th, I
Yeah.
believe?
I think so.
Okay, at 2 p.m.
Yes, sir.
Okay, I'll
right.
circulate that meeting invite probably tomorrow or before the end of the week.
Okay.
Second,
Awesome.
second Wednesday, right? Not Tuesday.
Oh, I'm sorry. Yeah, you're right. You're right, Mr. Beers. Wednesday. Okay. Awesome. All right. Thank you, everybody. We'll see you next month.
Thank you. Goodbye.